Welcome to Property Law 101. I'm Sara Bronin, and I created the series to help you understand the basics of property law. We cover 4 questions in the series, and today we're talking about the 4th, which is holding interest in property and the takings clause of the 5th Amendment of the Constitution. In other videos, we discuss regulatory takings, the mechanism by which government may infringe on property rights to such an extent that it is considered a condemnation of property. In regulatory takings cases at the Supreme Court, we have found that the economic impact on the claimant is an important consideration. We also know from the Lucas versus South Carolina Coastal Council case, covered fully in another video, that a total deprivation of all economically viable use of property will always be considered a taking. Once Lucas was decided, many plaintiffs tried to fit their facts into the Lucas framework when they were trying to dispose of a government regulation. What this means, practically speaking, is they tried to show they had a total deprivation. But you can't figure out whether a 100% total deprivation exists unless you know what the denominator is. So today we will go on a search for the denominator through 3 US Supreme Court cases. The first one is Palazzolo versus Rhode Island, decided in 2001. In that case, the owner of beachfront property tried to build a beach club on 18 acres of land. A state council applied the state's wetlands law, and the property owner appealed to court. One argument he attempts to make is that the court should separate the wetlands part of the property from the upland or the dry part of the property, and to consider the wetland part of the property to be the denominator. Doing so, he argued, would mean that the denial to build wetlands had deprived him of 100% of the value of the property, like Lucas. So the court rejects this argument and, really noting that the upland area can still be developed, remands the takings claim for deliberation under Penn Central. I should add here another key part of the Palazzolo case is that the property owner can still claim a taking even though the regulation existed at the time of his purchase. So in other words, Palazzolo knew that the wetlands law would restrict his use of the property when the property passed to him from the prior owner. But the Supreme Court says, again, this is separate from our denominator question from today, but the Supreme Court says that would not immunize the state from challenge. Okay, again, that's a side note. The following year, 2002, the Supreme Court considered Tahoe-Sierra Preservation Council versus Tahoe Regional Planning Agency. In that case, a regional government had issued a temporary moratorium for over 2 years to stop development in the Lake Tahoe area, which was getting pretty polluted. The question in that case was whether a temporary moratorium was something that fell under the Lucas per se rule. So the plaintiffs tried to convince the court to conceptually sever the months during which their property was under a moratorium from the entire parcel's perpetual existence. The claim was that there was such a total deprivation of the use of undeveloped property for the duration of the moratorium that this was a Lucas-style taking. The court says, I don't think so. There is no per se rule for a temporary moratoria unless there is some extraordinary delay, and maybe the court would consider that. But barring that, you can see why the court decided this way. To decide otherwise would have prevented governments acting in good faith to temporarily stop development so that they could plan for their community's future. Finally, we get to the Murr versus Wisconsin case decided in 2017. So this case has somewhat complicated facts. It considers 2 adjacent lots, which state and local law prevented from being used or sold without having 1 acre suitable for development. So that's the phrase to remember, suitable for development. In the case, the 2 lots were actually over 1 acre each overall, but had less than 1 acre each in developable area, an area suitable for development. When the property owners tried to sell one of the lots, they were stopped from doing so. So they challenged the law for the 1 acre minimum as a regulatory taking. The question then became, what's the denominator? The interesting part here is that both lots were owned by the same people. So what that meant was that local governments could merge the lots for assessment purposes and prevent them from being built upon or sold unless they were merged. The court said that this merger was valid and that the denominator was the unified lots, not just the parcel that the claimants wanted to sell. In Murr, the court established a balancing test. Oh no, another balancing test that included the way government classified land and the land's physical characteristics and prospective value, among other things, in determining whether the property owner was treated fairly. This was a victory for local government in an immediate sense. But for others, the test that the court set up in Murr may pose problems down the line. In particular, it continues Lucas's focus on the denominator. In the eyes of some commentators, we really shouldn't focus on the denominator. The only thing that should matter is how much is taken, and that's what we should compensate. So consider whether this search for the denominator, which has dominated Supreme Court cases after Lucas, is really a fruitful one, or whether it is something that we should try to phase out in regulatory takings jurisprudence. I will leave it to you to consider that question, and I will leave this conversation here. So I'd love to hear from you, whether on Twitter or through my website, where you can sign up to my mailing list, and I will see you next time.